What is the surprising history of non-compete laws? Imagine a world where workers could be locked into a job forever or prevented from ever working in the same field again. That might sound extreme, but it's part of the story behind non-compete laws. These agreements have been around for more than 600 years, starting in medieval times. Back then, apprentices learned trades from master craftsmen. To protect their skills and reputation, masters asked apprentices to sign agreements not to compete immediately after training. At first, English courts refused to enforce these agreements. They saw them as unreasonable restrictions on trade and workers' freedom. In the year 1414, a case called Dyer's case made it clear that non-compete agreements were not enforceable if they were too broad or unfair. But things started to change in the 1600s. In 1621, courts began allowing limited restrictions based on geography. Then in 1711, the case Mitchell v. Reynolds set a new standard. Courts said non-compete agreements could be valid if they were reasonable in how long they lasted, where they applied, and what they protected. In the United States, the story was similar. By the early 1900s, courts used a reasonableness test to decide if non-compete agreements were fair. They balanced what the employer wanted to protect, like trade secrets or customer lists, with workers' rights to move freely. The Sherman Antitrust Act of 1890, which fought against unfair business practices, also influenced how courts viewed these agreements. Initially, non-compete clauses mainly protected high-skilled workers and proprietary information. Over time, their use expanded to include low-wage workers and employees in many industries. This raised concerns about unfair restrictions and workers being unable to find new jobs. In recent years, lawmakers and workers' advocates have pushed back. Studies showed that non-compete agreements often limit workers' ability to change jobs and can keep wages low. Some states started passing laws to restrict or ban non-compete agreements for certain workers, especially those earning low wages. Most notably, in 2024, the Federal Trade Commission issued a rule banning all non-compete agreements nationwide. They said these agreements hurt competition and workers' freedom. This move was a big shift from the traditional court-based approach, which looked at each case individually. Now, the focus is on protecting workers from overly broad restrictions that can harm their ability to earn a living. Looking at this history, it's clear that non-compete laws have always been about balancing business interests with workers' rights. Over time, the trend has moved toward giving employees more freedom to change jobs and preventing unfair restrictions. Understanding this history helps explain why debates about non-compete clauses are so lively today, and why many are calling for reforms to protect workers' rights and promote fair competition in the labor market.